Hello, my name is Alex Proctor, and I'm the Chief Trust and Privacy Officer at Captain Compliance. This is the first of multiple videos that I'm going to be publishing surrounding the topic of privacy litigation. I'll be covering how plaintiffs' attorneys are using old wiretapping laws, like the California Invasion of Privacy Act, to bring lawsuits against companies that are using common modern web technologies. I'll also be talking about risk mitigation. In other words, the specific things that your company can do to reduce the risk of being targeted, and also how you can build a highly defensible website. Privacy litigation is a very deep and broad topic, so I'm going to break my material into at least a couple of different videos. The next video in the series will address another important type of litigation, and that will be the Video Privacy Protection Act from 1988, also known as the VPPA. I'll do a few other complementary videos as well. Here, we're going to stay focused on wiretapping litigation, particularly under CIPA. Keep an eye out for those additional videos. I always like to give a few key disclaimers up front. The first one should be quite obvious. There are major legal considerations to how you set up your website. You have choices to make about the type of third-party tools that you're going to use to enable your business, as well as how you're going to implement privacy disclosures and consent mechanisms. Keep in mind that it's perfectly normal for different companies to have different risk tolerances when it comes to the type of website tools that they're willing to use. I'm going to be providing lots of background context and also suggesting some risk mitigation steps that you can take. Just make sure that your legal team is involved with any of your website projects. The other point is that I'm with a company called Captain Compliance. Reducing privacy litigation risk is pretty much right at the heart of what we do. This is an educational video, but if you're interested and you need help, I want you to know that this type of risk mitigation is right in our wheelhouse. We can help your company build a highly defensible website, including with dynamic privacy notices and granular consent mechanisms that will reduce your risk exposure. I'll make contact information and other details available to you in the video description. Okay, now that we have that out of the way, let's get into this. There has been a very interesting privacy litigation trend happening over the last 3 years or so. Hundreds of website-related class action lawsuits have been filed based on alleged violations of very old wiretapping laws, most notably the California Invasion of Privacy Act from 1967. These lawsuits are commonly targeting companies that are running very modern website technologies, like pixels, chatbots, and analytics tools. Now, if you're hearing this for the first time, it might seem a little strange. Why would it be that a 58-year-old wiretapping law is at the epicenter of website privacy litigation when there have been so many modern privacy laws passed in the past few years? Wouldn't the newer laws be more relevant to emerging web technology than a law that was passed 15 years before the internet was born? Well, one of the reasons for this is that our modern privacy laws rarely include the private right of action. Out of all of the state-level privacy laws to pass in the last few years, the only comprehensive law that gives opportunity for individuals to sue is California's CCPA. Even within the context of the CCPA, that private right of action has traditionally been limited in scope to situations that specifically involve a data breach. Now, I don't want to get sidetracked here, but I will mention a timely development. There may end up being some changes in CCPA precedent based on recent rulings and interpretations. Litigators are constantly shifting and modifying their tactics. So if the CCPA's right of action is extended beyond the context of data breaches, and that extension is upheld, it would have important implications on the privacy litigation landscape. Ultimately, that's a topic for another video. And the point that I'm making still stands. In the majority of circumstances, individuals have not been able to sue under the comprehensive state privacy laws. I should also mention, some of the specialized modern laws do include a private right of action as well. Washington's My Health, My Data Act is the best example because it does include that right. But again, the main idea is that most of the laws don't allow for that opportunity, particularly when it comes to web tracking mechanisms. Anyway, this is one of the reasons why the old wiretapping laws are still so relevant. They do provide a private right of action, and they can be interpreted to apply to modern websites, even though they weren't even written with the internet in mind. They are absolutely filling a void for litigators that wish to challenge the ways that companies are operating websites and sharing personal data that they collect from third parties. Now that we've introduced the high-level trend, allow me to share a little bit more about the California Invasion of Privacy Act, also known as CIPA, as well as some of the creative ways that it's been used by plaintiffs' lawyers. CIPA was passed all the way back in the late 1960s. At the time, there was a lot of concern about the potential for phone calls to be intercepted via physical wiretapping. The type of technology necessary for eavesdropping was becoming more accessible, and there were concerns about unauthorized recordings and government surveillance and those sorts of things. There were also similar laws passed at the federal level and also in some other states. As you can imagine, in the 70s and 80s, wiretapping laws were mainly applied within the context of law enforcement and private individuals recording landline calls without consent. As you might expect, the laws evolved over the years. By the 90s and 2000s, they were starting to be applied to a wider range of communications technologies, including cellular communications and that sort of thing. Now, in the modern era, they are being used to litigate around internet activity, like activity relating to online tracking and even smart devices. The important high-level takeaway is that plaintiffs' attorneys are applying CIPA and those other similar laws to modern website technologies. If your business uses session replay tools, chatbots, or certain types of analytics software that involve third parties, you could be accused of unauthorized interception under CIPA. This is because third-party technology can be treated as a digital wiretap if not properly disclosed and consented to. A good specific example of this is a wave of lawsuits we've seen involving tracking pixels. Consider the Meta Pixel, formerly known as the Facebook Pixel. This tool is widely used to measure ad effectiveness and to retarget visitors across platforms. But when it transmits user interaction data, like visited URLs or button clicks, directly to Meta without robust notice and consent, plaintiffs have argued that it functions as a digital wiretap. We've seen hospitals, retailers, and publishers all face litigation based on their Metapixel implementations. It's just one illustration of how very common tools, when deployed without the proper safeguards, can expose companies to wiretapping liability. Actually, there are multiple different strategies that plaintiffs' lawyers are using to build their cases, relying on different aspects of the wiretapping law. We'll look at some of the nuanced details of these claims in the next few segments. At the high level, it's important to understand that CIPA-related risk can ramp up very quickly. The law allows for statutory damages of $5,000 per violation, which doesn't sound so bad until you realize that this can actually mean $5,000 per website visitor if each one experiences the same privacy violation. When CIPA claims are filed collectively as class action lawsuits, which, by the way, they often are, the aggregate damages have the potential to become massive and can be measured in the millions of dollars. Even when the lawsuits are settled early, they can still be very costly. The other factor that drives up CIPA-related risk for companies is the volume of CIPA claims that are being made. There have been well over 1,000 of these types of lawsuits filed since 2022. The plaintiffs' lawyers are, quite frankly, very opportunistic here. There are even certain firms that seem to have made CIPA litigation their bread and butter. I personally speak regularly with companies that have received demand letters and that are plotting their course of action. Like it or not, there are plenty of incentives for litigators to bring these sorts of lawsuits, as long as companies regularly choose to settle the claims, and as long as the courts are ruling favorably at least some of the time. Now, to that point, it's important to understand that there's been a great deal of variability in how these CIPA claims have been treated by the courts. Some have interpreted the nuances of the wiretapping laws more narrowly and have dismissed claims, while others have sided with the plaintiffs. Cautiously, I'll say that the current trends seem to be working in the favor of website owners, and it may be somewhat encouraging to know that a lot of these cases do end up getting dismissed for one reason or another. However, the main point that I want to make now is that wiretapping litigation should absolutely be a major point of awareness for businesses and website holders, particularly those that are running third-party analytics software and marketing tools. It's better to know the trends and to take relatively simple risk mitigation steps than have to suffer through a stressful lawsuit, which could end up costing your company a great deal of money. When I was planning this video, I was trying to figure out the best way to organize and share the important nuances of CIPA litigation that I want to discuss. I ended up deciding that it would make the most sense to talk through a couple of real-world, notable CIPA lawsuits, and then to use them as opportunities to bring up and contextualize some of these important points. Now, 3 cases won't give us enough context to cover every single aspect of CIPA litigation, but it should be a pretty good start, and it will give you an idea about what these cases are generally like. If you feel like this starts to get more in-depth than you'd like, feel free to skip forward past the case reviews. I'll do a quick summary at the end, and that's where I'd suggest you pick up. Before we look at any individual case, let me briefly explain what to expect from each. Javier versus Assurance IQ is going to help you understand what session replay technology is, the ways in which it's relevant under CIPA, the issues with retroactive consent, and why there's some tension between the comprehensive state privacy laws and ways in which CIPA has been interpreted by the courts. Yoon versus Lululemon is going to address privacy notice and consent failures, the difference between conversation participants and third parties, interpretations of the concept of communications content, and the notion of aiding or abiding a third party in eavesdropping. There are lots of practical takeaways to be learned from this case. Finally, Greenley versus Kochava is going to examine a more recent CIPA litigation trend relating to pen register and trap and trace arguments. If these terms don't mean anything to you, this could be a good one to review. We're going to start off here with an early and influential CIPA case, Javier versus Assurance IQ. The case is meaningful because it was one of several that helped trigger the modern wave of website wiretapping litigation. Assurance IQ was a direct-to-consumer insurance technology company. The company is no longer around today, having been killed off by their parent company, but they were active in 2021 when a plaintiff named Florentino Javier brought a CIPA lawsuit against the company. Like many insurance companies, Assurance IQ was in the business of providing insurance quotes online. They were also using session replay software on their website. If you're not familiar, session replay software is technology that you can put on your website to record and replay user interactions, including things like clicks, scrolls, and form inputs. With many of these session replay tools, the output is sort of like a hybrid between video reconstruction and a very dynamic log file. The point is to be able to analyze user behavior on a website, improve the visitor experience, or even help document the fulfillment of compliance actions that are required on the website. There are lots of these sorts of tools, and they're extremely common. You might have heard of Hotjar, FullStory, or Microsoft Clarity. These are just a few of the session replay tools that are out there. Anyway, Assurance IQ was using a particular tool called Trusted Form from Active Prospect, a well-known company. Now, Trusted Form isn't exactly a traditional session replay tool. It's more focused on lead generation, compliance, and consent, but it does have some specialized session replay capabilities built into it. Javier's allegation in the lawsuit was that Assurance IQ and Active Prospect violated CIPA through their recording activities as Javier went through the process of obtaining an insurance quote. The argument was basically that this recording activity, conducted without the consent of all parties, constituted an unauthorized wiretap of the communication. As a side note, California is in the minority of states that require all-party consent for recording conversations, unlike most states that follow a one-party consent rule. This stricter requirement, combined with the availability of statutory damages under California's wiretapping law, have made California a bit of an epicenter for these types of lawsuits. There's also a handful of other states that meet the same criteria and are also known for this type of litigation, albeit to a lesser degree. Initially, the Javier case was dismissed by the district court. The court found that Javier actually had retroactively consented to the collection of his information. This decision was based on the fact that at the end of the insurance application, Javier had clicked on a button titled View My Quote. As it turns out, that submission button had some privacy-related consent language wrapped into it. By submitting the form, Javier had accepted the terms of the Assurance IQ privacy notice. Well, later, in 2022, this initial district court ruling ended up being overturned. The Ninth Circuit Court of Appeals pointed to CIPA Section 631A, interpreting it to require prior consent of all parties to a communication. So the key word there is prior consent. Practically, by the time that Javier had clicked on the View My Quote button, along with its consent terms, he had already been using the website and typing his personal information into it for quite some time. The trusted form session replay recording was already well underway by the time that Javier interacted with that button. After the Ninth Circuit's reversal, the case was sent back to the district court, where it was ultimately dismissed again, this time because Javier's claims were time-barred by CIPA's 1-year statute of limitations. Essentially, Javier had taken too long to file the lawsuit, and the clock had expired. This leads me to the important takeaways from the case. Even though this particular lawsuit was dismissed for logistical reasons, it set important precedents through that Ninth Circuit ruling. At a high level, this case helped strengthen the idea that CIPA Section 631A, which directly speaks of telephone wires, can be interpreted to apply to communications over the internet. Now, this had already been pretty firmly established in previous lawsuits, but it was just another court ruling which established the point. Additionally, the case also established an idea that users cannot retroactively consent to session replay use. In other words, for the consent to be valid, it needs to be obtained up front, before recording is underway. This is a great time to point out that there is a bit of tension here between some of these wiretapping case outcomes and the comprehensive state privacy laws when it comes to the topic of consent. Every single comprehensive privacy law that's passed, including California's, allows for the use of opt-out consent models, including within online tracking contexts. This is actually the opposite of some other laws around the world, like the European Union's e-privacy directive, which specifically requires opt-in consent for non-essential web tracking. Of course, there are exceptions here in the States, like when companies are collecting data from minors, but explicit opt-in consent, retroactive or not, is generally not what these comprehensive laws require. The thing about this that can be difficult to navigate is that a company might set up an opt-out consent model, perhaps reasoning that they've aligned with the CCPA or other comprehensive privacy laws, and then find themselves in a CIPA lawsuit where the plaintiffs build a case based on the use of some web technology that hasn't required explicit opt-in consent to run. This could be a good reason to look at your cookie consent banners and their default behaviors in the United States. You may very well decide that firing non-essential cookies by default isn't worth the litigation risk, even if it's acceptable under the more modern privacy laws. Anyhow, the interpretations from this Javier case ended up being quite useful for plaintiffs, and certainly contributed to the surge in wiretapping class action lawsuits, which we've observed over the past few years. Now, I'd like to look at Yoon versus Lululemon USA, an even earlier CIPA case that played a key role in shaping the modern litigation trends. There's a lot that happened in this one, and I think it's a great example to look at because it gives us an opportunity to explore CIPA Section 631A in great detail. There were multiple arguments in this case that related to different 631A subsections. If you're not aware, Lululemon is an activewear retailer. They have physical stores and also an e-commerce website where they sell their clothes and merchandise online. Sometime prior to November 2020, when the lawsuit was filed, Lululemon had integrated a third-party tool called Quantum Metric on their website. Quantum Metric is a digital analytics platform that helps track, analyze, and optimize customer interactions. It's yet another very popular tool with session replay capabilities. To get a feel for how Lululemon was using Quantum Metric, you can simply look at the very convenient Lululemon customer success story on the Quantum Metric website. Apparently, the integration was quite helpful for solving various errors in the Lululemon checkout flow. The plaintiff in this lawsuit, Mary Yoon, was a California resident, website visitor, and customer. Yoon filed a CIPA claim against both Lululemon USA and Quantum Metric. The basis of the claim was similar to the Javier versus Assurance IQ case. Yoon alleged that Lululemon captured her website interactions as she was shopping, including her mouse movements, clicks, keystrokes, scrolls, and page views. Additionally, some identifying information was captured as well, including Yoon's IP address, physical location, browser type, and operating system. This information was all collected by Quantum Metric's session replay software and then made available to Lululemon and used for various purposes. Yoon claimed that this activity constituted an unauthorized wiretap under CIPA because she did not consent to Quantum Metric's participation in the communication. As typical in privacy litigation, some of the immediate points of consideration in this case had to do with both notice and consent. The first thing to know is that Lululemon did have a privacy notice. It contained a high-level statement suggesting that Lululemon shared personal data with unaffiliated companies and that third-party analytics services may be used for various purposes. Frankly, in my opinion, this is not the best notice content you'll ever see. It feels as if it was rushed and doesn't provide much useful detail, but it was available on the website at the time. With that said, Yoon was never directly asked to agree to the terms of the notice. Lululemon did mention it as part of the online checkout process, highlighting the fact that it was available, but there was simply no clear-cut consent mechanism. The court also took note of the fact that the privacy notice links on the Lululemon website were hard to notice, particularly because they used small, non-contrasting fonts. When the defense did attempt to make the case that Yoon had sufficient access to the privacy notice and that the notice provided enough information for Yoon to comprehend and implicitly agree to the role of Quantum Metric, this clearly was not the strongest argument, and as a result, the defense relied on different and complementary approaches. One of these tactics was to attempt to establish the idea that Quantum Metric was merely a participant in the conversation between Yoon and Lululemon, as opposed to being a true third party. This would actually be a very important distinction, because courts had previously agreed that the first two parts of CIPA Section 631A only apply to third parties. This is sometimes referred to as the participant exception. As you might imagine, the questions in this scenario quickly become something like, what is a participant? What is a third party? And how do you make a distinction between the two? Unfortunately, there's a lot of ambiguity here. The defense's case was that Quantum Metric was a participant in the conversation because Lululemon voluntarily and intentionally embedded Quantum script in its website, and that Quantum Metric acted on Lululemon's behalf. At the time, there had already been some other cases in which very similar arguments had been made. The other cases just so happened to have drastically different interpretations of the logic, and they generated all sorts of interesting metaphors along the way. In this case, the court ended up framing the question in the following way. Is Quantum Metric a tape recorder held by Lululemon, or is it an eavesdropper standing outside the door? If the answer was that Quantum Metric was operating like a tape recorder, it would be logical to consider them to be a participant. And if they were more like the eavesdropper, they would be classified as a third party. The court grappled with the question, considering whether or not the fact that Quantum Metric was a direct recipient of the data was enough to qualify them as a participant rather than a third party. Ultimately, the court rejected this notion, reasoning that a third party could still obtain data through a direct integration. The court also agreed with the plaintiff's suggestion that Quantum Metric collected, stored, and analyzed real-time data in ways that go beyond that of a simple tape recorder. The court ruled that more details on Quantum Metric's data storage were needed to settle the matter, and the claim remained alive with that tape recorder question unanswered. The defense's next tactic in this case was to focus on CIPA 631A Part 2. This subsection prohibits unauthorized interception and reading of any message, report, or communications contents while in transit. Quantum metrics suggested that it wasn't actually collecting the contents of the communication at all, perhaps collecting something better described as metadata when recording keystrokes, mouse clicks, page views, and shipping and billing information. They also contended that they weren't collecting communications in transit at all. The court sided with the defendants here, referencing a few examples of external case law. The court stated, "None of these pieces of data constitutes message content in the same way that the words of a text message or an email do." The court was ultimately of the opinion that content refers specifically to internal, user-generated material rather than routine identifiers which may or may not be automatically generated. This somewhat narrow interpretation limited the defendant's exposure under CIPA 631A Part 2. A final aspect of the case that I want to share has to do with one of the plaintiff's claims relating to CIPA 631A Part 4. This particular section prevents a party to the communication from aiding or abetting a third party in committing prohibited acts. The question here was whether or not conversation participants can be liable for aiding in wiretapping if they allow a third party access to the communication. Recall that the court had not conclusively ruled out the possibility that Quantum Metric was a third party. While there was a lot of variability in previous cases, the court sided with the plaintiffs here, stating that a conversationalist is betrayed equally by the wiretapper and by the willing conversation participant, who serendipitously allows that third party to wiretap. The end result of this case was a mixed ruling, which was delivered in July 2021. There was no clear victory for either party. While some of Yoon's claims were dismissed, the court allowed the claim under CIPA 631A Part 4 to proceed, indicating that further litigation was necessary to resolve that aspect of the case. This leads me to the important takeaways from the Yoon versus Lululemon case. Even though the case was voluntarily dismissed in 2022, it set some critical precedents that website owners need to pay attention to. At a high level, the case suggested that under CIPA, content can be defined narrowly, at least in some contexts. The court ruled that things like clicks, keystrokes, or billing info are more like metadata and out of scope from the type of content that CIPA protects. Keep in mind, different courts might see this differently, so it's not a universal rule. Additionally, the case made it clear that you can get in trouble for letting third-party tools access user data without proper consent. Your privacy notices have to be front and center, and you need solid consent mechanisms like an opt-in before tracking starts. Also, the whole participant versus third-party debate is still pretty murky and ambiguous, so you need to be upfront about how your analytics tools work and who's receiving the data. If you're writing a website, these are lessons you can't ignore. So far, we've looked at two influential CIPA lawsuits together. Both of these cases revolved around wiretapping accusations, with plaintiffs relying on different aspects of CIPA Section 631A to build their arguments. This was a very effective strategy for litigators between 2021 and 2022, as they targeted companies using session replay technologies, tracking pixels, and chatbots. Sometime around 2023, these wiretapping lawsuits started to lose a little bit of their momentum. It's not like these cases disappeared by any means. They were just starting to get dismissed a little bit more frequently, sometimes because plaintiffs weren't able to demonstrate that their communications were truly intercepted or accessed by a third party, and in other cases, the plaintiffs had not been able to demonstrate a true injury. Litigators began to adjust their strategies. Instead of focusing on wiretapping and Section 631A, attention began to shift to pen register law, which is reflected in CIPA Section 638(51). This law generally prohibits, with various exceptions, the use of pen registers and trap and trace devices. Now, if you're sitting there wondering what exactly are pen registers and trap and trace devices, you're probably not alone. Let's start with the traditionally understood definitions. A pen register is a device or process that records phone numbers dialed from a specific telephone line. It captures metadata, like the outbound phone numbers, dates, and times, but does not record the actual content of the communications. A trap and trace device is sort of like the conceptual inverse of a pen register. It's a device or process that captures the phone numbers dialed to a specific telephone line, along with the same sort of metadata, like dates and times of the calls. Like a pen register, trap and trace devices do not capture the content of the telephone calls. When CIPA was first passed in the days of analog phone systems, these would have been tangible electromechanical devices. However, just like with many other aspects of CIPA, creative plaintiffs have found ways to apply these concepts to modern digital tracking. Today, plaintiffs argue that tools like SDKs and tracking pixels can serve as the digital equivalent of these devices, and that's what courts are starting to entertain. This brings us to our next case, Greenley versus Kochava. Kochava is a data broker, described as a real-time data solutions company offering measurement, attribution, and campaign management for brands and platforms. As part of their platform, Kochava offers a software development kit, or SDK. The SDK integrates into mobile and web apps to collect user data, such as location, device identifiers, and behavioral information for advertising and analytics purposes. This enables their customers to track interactions, measure campaigns, and optimize targeted advertising. Kochava has many customers, and their SDK is integrated into what is presumably thousands of third-party apps. The plaintiff in this case was David Greenley. David used a mobile device and had installed apps that had integrated that Kochava SDK. Greenley's class action lawsuit alleged that Kochava's SDK was collecting sensitive personal data, including location information, without user consent, and even when users attempted to disable tracking. The complaint alleged violations of multiple privacy laws, including CIPA Section 638.51, the pen register section. As the litigation process played out, the CIPA claim was upheld, despite a motion to dismiss. The court ultimately concluded that the definition of a pen register under CIPA was broad and inclusive. Specifically, the court reasoned that Kochava's SDK, by identifying customers, gathering data like location and behavioral information, and correlating that data through a fingerprinting process, functioned as a pen register. The court explicitly rejected Kochava's argument that its software couldn't be considered a pen register simply because it wasn't a physical device attached to a telephone line. Instead, the court stated that the focus should be less on the form of the data collector and more on the result, the collection of routing or signaling information without user consent. The critical outcome of Greenley versus Kochava at this stage was the denial of Kochava's motion to dismiss the CIPA pen register claim. This decision was a significant win for plaintiffs, as it set a precedent for a broader interpretation of CIPA's pen register provision in the context of modern digital tracking technologies, including SDKs, pixels, and other website analytics tools. The fact that these technologies could plausibly be considered pen registers under California's law opened a door for a new wave of CIPA litigation, which the plaintiffs are still riding today. We've just walked through 3 different CIPA cases. I wish I could have included more, but this video is already running long, so I'll save additional context for future videos. So, what did we learn? I think I would distill it down to this. At the core, responsibly using modern web technologies, especially analytics and tracking tools, requires 2 things: clear, meaningful privacy notices and functional consent mechanisms. If you're lacking in either area, you are likely taking on much more risk than necessary and making it easier for plaintiffs to build their cases. There are countless ways that litigators and even regulators can challenge your practices. It's easy to get lost in the details. The truth is that strong notice and consent practices don't simply strengthen your legal defense, but they can actually reduce your chances of becoming a target in the first place. I mentioned this earlier, but it's worth repeating in the summary, and that is that there is an ongoing tension between the older laws like CIPA and the newer state privacy laws. You should carefully consider if you want to rely on an opt-in or an opt-out model when it comes to technologies on your website. An opt-in model is lower risk, and it's also more privacy conscious, but it often comes with business trade-offs. Meanwhile, opt-out may be legally permissible under the modern laws, but it's generally more vulnerable to litigation and might not always meet your visitor's privacy expectations. Another big takeaway is that CIPA litigation and privacy litigation in general is evolving rapidly. Courts are issuing new decisions weekly, and plaintiffs are constantly adjusting their tactics. The best strategy is to get ahead of this. Don't wait for a demand letter to arrive before you start paying attention to your website's privacy controls. I also want to point out one final thing. We all see the news stories that come out when state privacy regulators take their major actions. They make for memorable headlines. Honda was fined more than $600,000 in March, and if you're in the privacy space, you're probably well aware of that one. The ironic thing is that for most organizations, litigation risk under CIPA and other wiretapping laws is probably much more significant than regulatory compliance risk under the newer state laws. Both can damage your reputation, there's no question about that, but the reality is that you're much more likely to receive a CIPA demand letter from a law firm than you are to experience regulatory enforcement from the CCPA or one of the state attorney generals. In fact, several CIPA class action lawsuits have resulted in much higher payouts than any of the comparable state enforcement actions. Hopefully, it's a strong reminder that even if you're not subjected to the comprehensive state privacy laws, your exposure to privacy litigation may still be substantial and worthy of your attention. Okay, we've reached the end of the video. We've conducted a pretty thorough review of how old wiretapping laws are being used to target modern companies with class action lawsuits. We've also broken down how companies can reduce their risk exposure by offering strong notices and disclosures, as well as by offering privacy choices and consent options to website visitors. Believe it or not, these wiretapping laws are not the only old laws being applied in new ways. I mentioned a law called the Video Privacy Protection Act in the introduction. This is another law that's being used to bring privacy litigation against companies. One of my next videos in this mini-series will break down the VPPA and examine what can be done to protect your organization from related class action lawsuits. If your organization needs support mitigating any of this sort of litigation risk, Captain Compliance wants to be your trusted partner. Our privacy platform is designed to simplify compliance and reduce litigation risk, including by supporting the high standards of transparency and consent that we've discussed today. If you need more information, please feel free to reach out to me or visit our website. It's www.captaincompliance.com. I'll put a link as well as additional contact information in the video description. Thanks for watching.